My name's Martha Rands. I'm a lawyer in private practice, as well as the founder and legal director of the Pacific Legal Education and Outreach Society. And we are the organization that is hosting all y'all today. Always like to start out by acknowledging we are located on the unceded traditional territories of the Coast Salish peoples, the Musqueam, Squamish, and Tsleil-Waututh. We work throughout the province of BC and across Canada, making a practice of learning from and engaging with the nations upon whose lands we work. Today, we are talking about amendments to the Societies Act. Oh, joy, oh, bliss. And we are joined by Maria Turnbull, who is the interim executive director of Vantage Point. Looking forward to hearing the announcement in due course of the non-interim. And very happy to have her join us. We did a session in 2019 when the amendments were first proposed, and there was a consultation at that time. So some of this is not a surprise, thankfully. There are, however, a few surprises, and I'm going to turn it over to Maria, since I think today we are playing Stump the Lawyer, which is always an exciting way to spend an hour at lunch.
Thank you so much, Martha. And I didn't expect to smile or giggle quite as much over this lunch hour as I have done already since joining in for the prep. Welcome, everybody. As Martha shared, I'm Maria Turnbull. I'm the current interim executive director at Vantage Point, but I'm a long-standing team member with Vantage Point, coming into year 16, I think, which is a bit shocking, but it means, and I look forward to returning to my regular duties as associate ED, and really bringing that hat in a way to today's webinar, because my great joy is in facilitation, in convening work with not-for-profit leaders, and really accessing practical information. And that's one of the aspects that Vantage Point is so excited about in terms of partnership with Martha and PLEO today. I am connecting in from the unceded territories of the Squamish Nation, where I live in a place that settlers call Bowen Island, and in the Squamish language is Nuhweh. So welcome, everyone. We're just going to dive right in. Martha and I are geared up for a fairly close kind of fireside chat together. I've got all the questions that were submitted in advance, as well as a range of questions that Martha and I have crafted that relate to the key elements of the amendments that are being introduced at this time. But first off, just a bit of a general question, Martha. I think in the chat, Sarah's already shared the Bill 19, the access to the amendments, as well as a brief summary document. But can you tell us a little bit about when these amendments will actually take effect, Martha, just as a starting place, and how might we know that they actually are taking effect?
Well, the link is to Bill 19, which is the piece of legislation that is amending the Societies Act. It's past third reading, which means really now we're waiting for royal assent. And we don't know exactly when that's going to happen. I haven't had a chance to follow up to find out what the registry is planning. They may, in the past, they've actually sent a notice to folks, but I don't know if they'll do that this time. I'm hoping so. My guess is that we'll see it royal assent by I would imagine January 1st this will be proclaimed in force. Now there are a few of the changes that are going to be that are going to take effect by regulation, meaning that the regulations will be amended. Those may happen under a slightly different timeline. depending on what else is on the legislative agenda and other factors. With respect to one of the new provisions, which we'll talk about, for those who are interested, it might not be a bad idea to reach out to perhaps Nikki Sharma around some of the changes and seeking directly from folks.
Okay.
Some time, some additional time to adjust to some of the changes, the one in particular being the record keeper role, which we'll talk about in a moment. So that's the long answer to the short question.
Yeah, no worries. So, let's dig in, because one of the questions submitted in advance actually is sort of top of our list in terms of how the amendments might impact our bylaws. That'll be the big question, I think, for lots of boards. And I can quickly answer a question just came in about who is Nikki Sharma. So Nikki Sharma being the parliamentary secretary for our nonprofit community sector. Martha, would you add anything else in terms of Nikki Sharma's role?
No, she is the person, though, that if there are, any issues, particularly we should reach out to, because her focus really is to hear from the sector.
Yeah, great. And I will be taking notes in terms of practical impact, because Vantage Point is in communication with Nikki Sharma at points, and look forward to capturing what makes sense for those conversations from today's webinar. So regards to the bylaws, in the 3-page overview PDF that Sarah's provided the link for, this gives a good quick summary, but it doesn't tell us kind of, I looked at the summary of the changes that are presented in this short PDF and still had lots of questions, and those are the ones that I've highlighted for Martha. So regards to bylaws, it talks about changes around providing rules related to directors' period of holding office, and making allowances for conflicted directors or senior managers to remain in a meeting. Could you talk us through some of the relevant kind of rule changes in this area, Martha?
Yeah. Well, I would say they're less rule changes and more clarifications. What's happened is that with the quote unquote New Societies Act, which came into force in 2016, it requires that societies identify term limits, the term of directors if they are going to be for more than 1 year. And that was to ensure that it was clear to the membership how long a director would be elected for, how long their term would be. And what they've done with these amendments is address the time frame within which directors could be sitting. That is to say, clarifying that if the term of office of a director is 1 year, then that term will end as of the close of the AGM. That is something that causes quite a bit of confusion in people, in my experience, as they wonder, well, when does it end? When does it start and when does it end? It starts at the AGM you are elected and ends at the AGM, the close of the AGM at the end of the year. But the idea behind these changes is to clarify and ensure that it's clear how long somebody is going to be a director and when it starts and when it ends.
In regards to sort of the second part of this around the allowances for conflicted directors or senior managers to remain in a meeting, this was something that stood out to me from the amendments, because I've had lots of questions about conflict of interest as it is outlined in the requirements for directors and senior managers regards to their leaving meeting during discussions where a conflict of interest exists. So could you briefly describe how these requirements are having an impact, a positive impact potentially?
Yeah, I think that, there's a lot of misunderstandings around conflicts of interest. people kind of freak out and they're never really sure whether or not a director or another individual conceivably is in a conflict of interest. And so we are doing a webinar just on this topic on November 24th. That will be up on the website next week, so people can come back for more on this. Traditionally, what one does when one is addressing a conflict of interest is Director X. You're going to talk about who's going to do the website for the society. Director X's sister has offered to do it for free. Director X is therefore in a conflict of interest, and they are expected to recuse themselves from the discussion and certainly not to vote. And what often takes, getting them out of the room often happens, though, there could be real value in having the director perhaps explain why getting the website for free is better than not. I mean, this isn't a particularly good example, but there are situations where the board is going to be making a decision about whether or not to waive the conflict that the director is in and enter into the contract with the sister in that case. And they may wish to hear from the individual. The important thing is that they control that process. And my guess, well, it's more than a guess, part of the reason why all of these amendments have come up is because these are the issues that have come to the registry's attention as people call the registry when there's a problem. This is also an issue that has come up with the Civil Resolution Tribunal, where there have been disputes about whether or not directors are in fact directors and who's a director, and those also are driving these amendments.
Sure. So, and you know, maybe sort of just flagging there in terms of the spirit of many of the amendments. Hopefully, they are an enhancement, a clarification. I know not in all cases are these. Will that be the case in terms of it being a positive orientation, perhaps? But we'll get to some of the trickier ones. That we did have a follow-up question regards to directors' terms, and just think it's timely to answer it here. Are there any changes regarding how many terms a director can be in office? No,
that's the consecutive issue. That's, a director can serve 2-3 consecutive terms. That might be the language in your bylaws, or you might not have any language in your bylaws, which allows for what might be called the perpetual director. Every year they just get reelected, they just never leave. They're great, and until maybe they're not great. Not that ever happens. So yeah, no, there's no guidance on that specific point. There's also nothing in the amendments that addresses staggering, which is also something that comes up all the time. It's how do we stagger this? And I think the main question here is really around, do you have good policies in place and procedures on how you keep track of your directors? What often happens is that we, over time, stop electing people at AGMs because they're the perpetual, it's always been the same people, they just stay on, we never ask, we don't go through a process, and we lose track of how long somebody's been a director, especially if we have staggering. The number of times, 5 years later, you're like, wait a minute, when did they start? And you have to go back into the actual registry files to find it, because the minutes don't actually reflect, the minutes of the AGM don't actually reflect that the person named Bob Smith was elected for a 2-year term to end on such and such a date. So there's all this fuzziness that results. And that fuzziness is also the underlying the amendments around the register of directors.
Great. So, and that's exactly where we're headed, Martha. Nice segue. Just a little bit more about any changes that relate to directors, starting with that register of directors. Yeah, can you give us a brief on what's changed there?
So this was in the absolutely in the proposed amendments in 2019. It was discussed in the white paper that that went with those amendments at the time. And the issue here is that directors, when they resign immediately, that should take effect immediately. And certainly the tax courts, when asked, when they see that an individual has taken the time to resign from a company, from a corporation, and there's a letter and a date, they are no longer on the hook for, they no longer carry the fiduciary duties. And I think what's happened, again, this is just it's that directors are trying to get off boards, and for whatever series of reasons, usually because people are too busy, lack of capacity, whatever, maybe it's an all new board, they don't have the registry key, and they just haven't updated the filings with the registry. And then Jane Smith finds out 8 months later that even though she resigned, she's been on the register. So technically, legally, she shows up as a director 8 months after she resigned. And the changes in the proposed act, or the proposed changes to the act, will allow a director to actually change the register, so that they can basically do an end run around, for example, if there's a conflict on the board, and or with staff refusing to do anything, they can just go directly to the registry and say, here's my letter of resignation. They've not changed the register. Please change it.
Great. And regards to directors, I think you've already mentioned the clarification the amendments provide regards to a director without a term of office will cease to hold office at close of the first AGM after becoming a director, unless the bylaws provide otherwise. But the other change we haven't talked about relates to allowing a person who was incapable of managing their own affairs but has since been found otherwise to be a director. Can you shed any light on that one?
Right. So when they changed the Societies Act in 2016, there was a revision to address qualifications for directors. And those provisions, as most people know, indicate that a director cannot be an undischarged bankrupt, nor can they be someone who is incapable of managing their affairs pursuant to the Adult Guardianship Act. And thirdly, convicted of very specific criminal offenses related to fraud and related economic or white collar offenses, financial crimes, that's the word. And there was some concern, I suspect, raised by advocates for folks who may actually be operating under an adult guardianship order, that can change. For example, not unlike Britney Spears, it's very different, but many people understand that Britney Spears for 13 years had a conservator appointed. That is actually a very much more, it's a whole other ball of wax. However, these things can change. And in some cases, an individual could be declared not capable of managing their affairs, but that could change. And this amendment allows for the possibility that it can change, and that person would then be able to be a director. Just like if somebody were to be an undischarged bankrupt, and all that means is that they didn't get discharged by the court. So all they really have to do is file the paperwork to be discharged, and then it's no longer an issue. So having been an undischarged bankrupt once does not disqualify you from acting as a director so long as you've been discharged.
Great. Thanks for that, Martha. Sort of as we dip into access to records, because I think this is another critical area of interest probably for participants. So shifting gears a little bit, regards to access to records, starting with the amendment related to societies that restrict members' rights to inspect the register of members. So what limitations are coming in here, and what's the relevance that might be important for folks on the call?
Right. So if anyone has been keeping track of civil resolution tribunal cases, then you know that the majority of the decisions relate to access to records requests, which is actually consistent with also early strata decisions as well as co-op decisions. And, it's been an issue pretty much in every case I've been involved in, where an individual is requesting the register of members because they want it, not because of not based on either a requisition for a special meeting or putting a membership proposal before the membership, or thirdly, communicating for the purposes of the requisitioning of a special meeting or a membership proposal. And those are the reasons under Section 27 of the Act that once the board has passed a resolution limiting and restricting the individual's rights under the provision, then they can limit it. However, what's happened is, in many cases, the board has not done that, and there's no restriction in the bylaws. So the CRT has taken the position that as there's no resolution from the directors, even though I would argue that a letter or email from the president of the board saying you don't get it is sufficient to rise to the standard. You have to give us reasons, etc. The CRT has said you have to disclose the membership register. And what this change will do is make it absolutely clear that the only way you get the register of members is for the purposes under the Societies Act or for some other very good reason. So this is a really good, I think this is really important because one of the issues we have with the CRT is they've taken a view, for example, that an individual who's no longer a member of the society, who made a request for a record a year ago and when they were a member, is not only entitled to the record, they may be entitled to 10 years worth of those records. Mm-hmm. And I've seen an order of the CRT where they order, in fact, 10 years of records, even though they don't appear to inquire as to whether or not the individual who's asking was even a member for those entire 10 years. So, I think the way they're understanding their jurisdiction is overbroad. I think and there's a recent decision that I'm hoping will be judicially reviewed, the Oakley decision, in which accounting records, which were not restricted in the society's bylaws, were ordered disclosed to the member who also was no longer a member of the society, and that they ordered that those accounting records be provided in an unredacted form. So, which I think is wrong. I think I know they're wrong. they misread section 18 of PIPA. And so we're hoping, look forward to seeing some movement on that, because it's a really problematic decision. But it is a good time now, since we have 100 of you here and anybody who watches this after, please, please, please look at what you have in your bylaws. Restrict access to accounting records and directors' meeting minutes in your bylaws. It's an important restriction, and it isn't about democracy, and it isn't about having anything to hide. But the general ledger is not something that should ever, in my view, actually ever be disclosed to a member, period.
Thanks, Martha.
Yeah.
In return, I think the only other area of access to records was specifically for a guide for societies to simply make a record. When making a record available for pickup, the society must send the recipient a notice that the record is available. That one seems pretty straightforward. Regards to the register of members, because that was in the first question under access to records. Just it sounds like some clarifications about what information is allowed on that register of members that's then provided, given access to. Right. And so, yeah, please tell us more.
Thanks for reminding me. So the way the Act read was name and contact information. It actually says one piece of contact information, but what I'm sure was happening was the membership register that was being disclosed included a lot of other information as well, and that people were not hiding that information if they were using an Excel spreadsheet. One of the reasons why in our privacy and record keeping webinar, I insist on creating a completely new document that only has the name of the individual, the class of membership, and one piece of contact information, was to try to reinforce that. And this clarification will ensure that the only information are those three pieces of information, nothing more. And again, what there hasn't been is consideration of whether, for example, mailing address is sufficient for the purposes for a bona fide purpose of disclosing the membership register. It's interesting to think about when you have a large membership and you're requiring a member, a requisitionist, they would have to send everything by mail. That could be cost prohibitive. So I think for those, that could pose some some issues, but definitely it's within the four corners of the Act to just give the residential address.
Great, thanks so much, Martha. I'm going to move along to errors in the statement of directors and registered office. So a couple of points here. Societies will be obligated to file a notice of correction if they become aware of an error in their statement of directors and registered office. And a new application will be introduced for individuals to apply to the registrar to have their name removed from a statement of directors and registered office when it is included in error. And I think you spoke to that one already. How long would a society have to report an error, for example?
Well, this is something that actually there is a special form called a correction. And for a while it was free. But I think it's $15 now. We make mistakes, correct them. And actually, if, for example, one of the things that people did is they uploaded to their dashboard the wrong documents, for example, with the transition especially, some people uploaded their transition, the package that they got from the registry, not the bylaws. They just put the entire package in because it was all in a scanned form. you can address that error by just filing a correction. And this is an important, I mean, I think what's been going on is that, I have a file I worked on 3 years ago, and a new board member wants to know that the society transitioned correctly. And she's a lawyer. She's written to me twice now asking for confirmation. And I'm like, well, I don't have access to the registry. You do. So, and I've explained to them, you can actually just call the registry up and change the registry key, so that you can access the registry. But this happens all the time, is that a new board, you could have a whole new board every year for that matter. It doesn't happen that often, but it could. And, where do you keep the registry key? Right. So, and again, when you have disputes where the board, also resigns en masse, that's a problem, because the only people who have access by right to change the registry key are the directors. And also the where the mail goes. Does it go to whose office does it go to? Does it go to the society's office, or does it go to somebody's house? If that person has resigned, that could be a real problem, because that means that documentation is going to their house. Emails also, it's going to, Maria Turnbull at gmail.com, not Maria Turnbull at vantagepoint.ca. This is a massive issue. And sometimes, I'm incorporating societies, and people give me their personal emails, and I have to remind them to change it. Please change it to something that is the society's email and that everybody has access to. But these are the kinds of things they just fall through the cracks, right?
Yeah, I highly recommend, I've been a board member of a working board that didn't have very good knowledge transfer practices from one board of parents of a small preschool to the next. And I can't tell you how everybody on the call, how critical it is just to have some of those basics documented and available to your next board, especially where there is that regular rotation. And once you have access, in fact, to do these tasks online is very easy, but it's just making sure you have the right access, and then that the notices and information is, as you say, going to a place that's accessible to the next group of board members. Moving along to, this was the section that caught my eye, disclosure of remuneration, mainly because when the current act was brought into place, there was a lot of discussion around the point of disclosing employee and contractor remuneration that was over a certain amount. And it looks like the amendment takes it further from what I can tell. But if you can, so that will require societies to disclose remuneration of all employees and contractors over the threshold of 75,000. Can you tell us a bit more?
Yeah, I will have to say I do not know the rationale for this one. Other than, I guess, it would make it fairer in the sense that it should apply to everybody, and it shouldn't be distinguished on, if there's 10, just the top 10, you have to disclose it, all the ones over 75,000. That's really the point that it's getting at. If you have 35 staff that are paid over $75,000, then you need to disclose you've got 35, the aggregate amount is X, right? That you don't limit it to the top 10. I think this is a highly problematic provision, and it has been since 2016. It's directed to greater accountability, but I do wonder, and this is the point that many of us raised at the time, is that, for those of us that are charities, we're already reporting bands within salary bands, and why isn't that sufficient for the purposes of under the BC Societies Act? And it's also a level of of transparency that's not required of the private sector, which does sort of beg the question when government is also, giving money, spending money on private contracts, software, this, that, and the next thing. So, there's there's some problems, but it is what it is. So if you've got more than 10 staff and you thought you could limit it to the 10, that won't be the case moving forward.
Yeah. Thanks, Martha. I'll get us kind of moving through into the meetings section, but just want to pick up on a couple of sort of related comments that have come through. Regards to reporting errors, somebody asked, can you wait for annual report to correct if it's not a major error?
Somebody's at the door, so I'm going to go answer.
Okay, all right, we'll hit pause for a second. Regards to, and I'll just address some of the other questions that have flown through, some in the chat box. Puneet asking the question regarding restricting different elements in bylaws, in particular access to what sorts of records, and yes, absolutely, bylaws are the place to do that, to give narrow the access. I'm checking in with Sarah behind the scenes because I think PLEO did a previous webinar specifically on access to records. And so hope we can get that to everybody to serve as another resource.
Yeah, and I'll be updating it. I think I'm going to do it in early December again, and I'll do it as a way to, instead of editing the previous one, we'll do a new one with the updates. And I should say that our legal self-assessment and learning tool is launching, soft launching in this week, actually. So you'll get an opportunity to test it out next week. I encourage all of you to have a look at it. There are some areas that we'll have to make some minor changes to, but for the most part, it should be consistent with these changes as well.
Thanks, Martha. And there was a general question, which I'm sure will be quick for you to answer. Once we change our bylaws to reflect the amendments in Bill 19, do we have to convene a special general meeting to get them approved by our membership?
Well, any changes to bylaws are going to require a general meeting of members. Whether you do it at an AGM or whether you do it at an SGM will depend on the circumstances. For those of you who have adopted standard, the Schedule 1 model bylaws that were attached to the Act in 2016 and haven't made any changes to those, other than an access to records provision, you may not need to make those changes. The issue really does come up. I think where we will see changes is your society one of those societies where you feel that you're going to need to add bylaws? I think that's the real question. It's going to be, do we feel we need to clarify this? Is this something that we think we need to ensure clarification? Now, I will say that the candidates, the societies that I see are the candidates for making amendments to their bylaws as a consequence of this, these amendments, are really going to be ones where you've got a membership base that could become restive, or, as I like to say, the mischievous member comes along and upsets the apple cart. If you're engaged, if you have a really engaged membership where the possibility of people disagreeing or the area that you're working in is contentious. I mean, when I look at the cases and the Civil Resolution Tribunal, I see quite a few from community associations. Those are residents of smaller communities where the community is an unincorporated entity It's not a municipality, I mean, and they've come together to manage community amenities for their small community. And that's when you start to see, as in Harvey, as in Oakley, the rest of the mischievous, the member who just doesn't want to take no for an answer. And those are the people, those are the groups where you probably want more specificity in your bylaws than it exists in the Schedule 1 model bylaws or the old Schedule B bylaws, which if you did nothing in 2016 to 2018 and just uploaded your old Schedule Bs, sure, they comply with the Societies Act, but maybe you want to be looking at some changes now.
Yeah. Martha, a couple of follow-up questions related to the remuneration disclosure, sort of some questions around, well, where do you even disclose that? Who are you telling? Who are you disclosing to? Where does that disclosure show up?
On your financial statements. So this is something, if you are an organization that uses an accountant or an auditor, they should already be doing this and telling you this. If you have been dealing with someone and it isn't there, that suggests to me that they're not up to speed on the requirements, because this has been widely shared across CPAs, etc. So, but it is on your financial statements. If you have a bookkeeper, they should know this and they should incorporate it into the statements that they generate out of the general ledger, or your treasurer. It would be unusual in my experience for you to have people working at salaries of 75,000. Well, I suppose some small organizations, you could just have one staff person. So maybe you are just using a bookkeeper who may not be aware of this. But most bookkeepers who work actively in this space should know that you have to disclose, and it's a disclosure to your members. That's what it is. And you know, there are circumstances where members of the public can request copies of your financial statements. So, you know, this is why it's a contentious issue, because, you know, you get the financial statements and, you know, and then it becomes, you know, open, finding out that the 420 Society, the person who started it, who was running it, their salary becomes obvious.
Thanks, Martha. I am going to move us along to meetings because we've got some good ground to cover, and I want to make sure at least I leave you a little bit for the new requirement regarding a record keeper. So I will have to move us along a bit more quickly. Continue to add in your questions to the Q&A, please, and if there are any that aren't answered during the session, we'll work with PLEO to see how we might get some follow-up comments sent out. But regarding meetings, so a number of changes that are summarized again on that 3-pager that we've referenced a couple of times. First one seems pretty positive. It provides that minutes must be kept for general meetings only and not for other gatherings. Any comments on that one?
Yeah, I think there's some confusion because some groups do meet with members outside of an annual general meeting or a special general meeting. And those meetings do not have to be minuted.
Okay, not to say that our directors' meetings don't need to be minuted. Yeah. So regards to directors' meetings, a few areas here. Directors may only pass a director's resolution without a meeting if they have already sent a copy of the resolution to all directors. And then passing the resolution requires all the directors to consent, or a lesser number if allowed for in bylaws.
This is the, we want to get rid of a director, but we'll leave them, so we'll leave them out of the conversation and then we act. That's problematic. Most bylaws don't have specific rules on consent resolutions. As a consequence, they require unanimity, which means that if you're trying to toss a director out from the directors, they have to be advised of that very resolution, and you're not going to get unanimity, which means you're going to have to hold a meeting and talk about it. You can't do it by consent resolution. Unless your bylaws say that when 75% of the directors agree in writing to a resolution, that it is adopted as a consent resolution. But very few societies that I work with have ever bothered to do that.
Another one, alternative directors or proxy voting at directors' meetings will be prohibited.
Yeah, I was surprised to see this actually, because it never occurred. Well, I guess it happens, right? Again, this is you're trying to get somebody off the board, and, so you say, well, we'll give you our proxies. Proxies have to be set out in the bylaws. And in this instance, it would be highly problematic for us, because in theory, a single director could hold the proxies of everybody on the board, but the person who's being tossed. And that's really problematic. It's a conflict of interest. There's any number of different ways of framing that as a bad thing. So they're just trying to get rid of that possibility, which I presume is because some people have done this.
Right. Yeah, I've never assumed it was allowed. So that's, glad to get the clarification, I guess. A couple last ones on meetings that relate again to conflict of interest. So first off, if a director or senior manager is reasonably unaware of a conflict of interest, they are not required to disclose that conflict. Is this kind of opening a can of worms, and it might take us too long as to what was the threshold of reasonably unaware?
Yeah, I'm always one of those people that's a reasonableness, like, the reasonable man standard. Well, I'm not a man, it doesn't apply to me. Yeah, opens a whole can of worms. I'm sure it's intended to allow people to say, well, I had no idea because I haven't been to the last 4 directors meetings and I don't read the minutes. Is that reasonable? No. So I don't know what, I'd love to see the rationale for that one. But I do think it's important that, we'll talk about these at the next webinar in November.
Okay, sounds good. I will shift us over to the record keeper requirement. Martha, I'm just sort of fast forwarding just with we've got about 11 minutes on the clock left, and I want to make sure we don't lose this one. So a new requirement. Can you give us the lowdown and any of your concerns?
Yeah, so historically, when you dissolve a society, even before 2016, it's a little bit simpler now, but it was not that complicated. You would get passed a resolution at a members meeting, and then once the liabilities were attended to, the directors would swear an affidavit, you'd submit the application to the registry, and the society would be dissolved. What has arisen is, as a consequence of access to records provisions in the new act, is questions about, well, who's responsible for the records post dissolution? And when you're a large, when you're an entity, a very small entity, I don't know that anybody's going to come back and ask you. I mean, arguably, you've passed a member's resolution to dissolve. That means, and you gave notice, so everybody knew, and there was a resolution passed. And in my experience, it actually takes a few months to dissolve. For most groups, even a year. They may want to wait till the end of the next fiscal year. So I'm not sure that this is as big an issue as the registry and the drafters appear to think. But they've decided that it is a big issue, and they want an individual appointed as a record keeper. I don't know how, and then after dissolution, this person would then have to answer an access to records request, presumably made by a former member of the society. And I'm like, okay, how are they going to pay for that? First of all, if it's a lot of records, which in some cases it could be a society that's been around for a long time, we're seeing a lot of amalgamations, particularly in childcare, in areas where, it's been hard to find space. So where it used to be, two groups sharing a space, operating as two distinct entities, they amalgamate into one. One of them is going to be dissolved. So maybe in that case, it's easier because there is a continuing entity that will keep the boxes somewhere, or the files in the cloud somewhere. But for a lot of societies, it's we're done. Bye. Here's some money so you guys can carry on our work, but we be gone. We be done. We bye-bye. Especially since the pandemic, there's been a record number of changes, combinations in the sector, and also dissolutions, at least in my experience. So appointing a record keeper, this is the provision that I think we need to go to the Minister of Finance, that is Selena Robinson and Nikki Sharma, and say, hang on, we're going to need time to figure out how this is going to happen. And we also need to know, like, this person is going to be allowed to charge fees. Well, who's going to pay the fees when there's no money in the bank and you can't access the bank account because the society's been dissolved? Like, how would this person be paid and by whom? So I think there may be some logistical problems here.
Well, I'm even imagining in terms of being offside with that particular requirement. Well, does it, in whose universe does it matter? Yeah. And, this is where we get into, the great diversity of the sector, like, it's one thing if you're the Family and Children's Services of BC or Vancouver, Greater Vancouver, or Big Brothers, Big Sisters, and where theoretically you're stably funded, even though arguably it's been a gong show the last 18 months. So I don't wish to be saying that it's somehow better. It isn't. And, the quilters of Penticton, like, why would the quilters of Penticton, if they just decide we don't actually need to be a society anymore, we'll just be a club, right? And you do wonder, like, why would you even be like, could be a serious disincentive for some groups to even incorporate. Actually be a good reason not to incorporate, frankly, if you're just a club. But the problem is that banks now are requiring incorporation before they'll open a bank account if you're a group of people. So it's a big problem. Bit of a clarification here, and so, unfortunately, most of us, even when we were preparing for this webinar, if you remember, Martha, I said, regards to thinking about dissolution, many of us as EDs, leaders, aren't going to be thinking about dissolution unless, if we're still hoping we're an ongoing concern and have a relevant mission and so on. But regards to this record keeper, the kind of the access to records here and even in other areas that we've touched on, is it like a 7-year length of period? Is there in terms of period of time that documents need to be available?
The act requires that relevant records be kept for 10 years. So, well, that's a lot of records to be keeping. And this is separate from financial records. But this does raise the question, which does come up when you dissolve, where do the records go, right?
Yeah.
And, in many cases, it can stay in the person's garage without too much trouble. Like, historically, I don't really worry about this kind of thing because people mean well. The groups that I've assisted in dissolution, they've done everything tickety-boo, they filed their taxes, and they're gone. And yeah, there's a bunch of records sitting at somebody's house, but they're keeping them primarily in the event that the CRA comes back and says, hang on, we have a question respecting the finances. That seems to me to be enough. This takes us into a domain of like, how would they be paying these people? And who would want that onerous responsibility? Especially, let's say you were an organization with 700 members and you dissolved because nobody square dances anymore. I don't know. Like, who in the world would want the responsibility for 10 years of being the record keeper? So as to answer, you have a dispute with Bobby Sue, who wants you to wear pink and you really prefer purple. I mean, please. Oh, and I'm going to make an access to records request. Well, you were once a member, so then I have to give it to you, but I have to engage in this whole process without any understanding. Like, there's no recourse here. Yeah. Why would you even give a member access to records when there's no society anymore? Like, I understand. I think I understand why they're doing it at some level, because of this question about some potential liability. But I'm like, boy, oh boy, we can't even get into our bank account if the dissolution happened and left money in it. Like, it goes to the state. So I'm like, hang around. I would be willing to bet you dollars for donuts that there's enough money left over in bank accounts from societies that goes to the province's operating coffers to enable us to address this by just saying no. Like, I don't get it.
Yeah. So I'm hearing, and Martha, you warned me that you'd be happy to get on a box to talk about that one. So I'm glad we saved a bit of time for it. And, and hearing that there's an opportunity there in terms of sort of raising the flags with key decision makers regards to the sensibleness behind some of that new requirement for record keeper. Just picking up on it, there's one last question I could spot here. Somebody asking, we recently changed offices. Do we need to do any registration since we now have a new location for the records?
Absolutely. If you have a new location and the office has changed, absolutely file the change of office, because you're asked both mailing address, meaning where do they send stuff for service, and the physical location, and they could be two different places.
Yeah.
Yep.
Go ahead. You finish that thought, Martha.
I'm answering the question on the LOTA. We're doing a webinar on November 8th.
Oh, brilliant. Thank you, Martha.
So,
and then
we'll have that going out to people. Please sign up for our newsletter if you haven't already.
Yeah, I can completely testify to the importance of getting the PLEO newsletter for regular updates. One last question in regards to the record keeper, clarifying that this person only appointed if the society shuts down or dissolves. Clarifying that there is no appointed record keeper while the society is up and running, correct?
Yeah. But it's a good question.
Perfect. So we are at 1 o'clock. I'm certainly happy to stay on a little bit longer, but maybe Martha and Sarah, I don't know if you want to do a close and then we can confirm or just alert to. I think we've captured most questions along the way. So happy to hand back to you for closing.
Yeah, I think this is really the beginning, right? There's a whole whack of amendments. I think the message, though, really needs to be don't panic, number one. Also, we'll make this recording available. We are going to be amending our FAQs that are up on the Click Law website. So as things change, once the act is in force, hopefully we'll have time before the act is in force for us to make the changes. I don't expect they're going to happen like next week, I hope. And I do encourage all, I think Marie and I may take this up afterwards, the possibility of drafting a short letter to Selena Robinson about the record keeper issue, and at least alerting her and Nikki Sharma to our concerns, the possible concerns that we've heard today, because I think just your questions alone tell us that there's quite a few questions. And I don't know, I will say just to thank you, Maria. And I see that Judy Piggott, I don't know if you're still there. I just want to make a special mention. It's good to see your name today, and to tell everybody that's still here that we wouldn't be here without Judy. She literally was our shepherd over many years, my shepherd. I don't know if shepherd's the right word, am I a sheep or not? But anyway, I just really haven't had a chance in so long to speak to you, and really want to thank you for all of the support over the years. And that's it. And good to see you all, and or not see you all, as the case may be. And